Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.
From St. Louis Public Radio. This is St. Louis on the Air.
The Eighth Circuit says it's premature to decide if it's a class action, but if you dare test it and want more discovery, we're going to take away your injunction. It's absolutely punitive, and I was frankly offended by it.
I also think some businesses are going to just create some secondary place and say they're working from there.
Just to save their workers that money.
Just to get around it if they would lose in the courts.
Wow.
Yeah, that's a 1% raise for your employees. That doesn't cost the employer anything.
His guess that 75% of the people who pay earnings tax actually live outside of the city.
Oof.
And so if even half of those people were working from home, you know, that is a devastating blow. So I don't blame Greg Daly for fighting this. This is a lethal blow to the city, possibly. You know, the city may have to completely alter its budget.
I'm Sarah Fensky. Today is our legal roundtable. We'll discuss the legal arguments around the legislature's apparent balk at funding Medicaid expansion, despite approval by state voters. We'll discuss the legal issues surrounding the resumption of jury trials during this pandemic. And we'll also discuss challenges to the city's earnings tax. If you work at home in the suburbs, do you still have to pay it? The legal questions here are complicated, and joining us today to discuss them is a panel of ACE attorneys. Mark Smith is an Associate Vice Chancellor and Dean for Career Services at Washington University, as well as an attorney. Mark, welcome back.
Thanks. Good to be back.
And we're also joined today by Sarah Swatosh. She's a partner at Sadeh Harper Westhoff, specializing in employment law. Sarah, welcome.
Thank you.
And last but certainly not least, this month we're joined by Jennifer Joyce. She's the former St. Louis Circuit Attorney. She held that position from 2001 to 2017. She's now a principal in the consulting firm Vera Causa Group, LLC. She works with prosecutors around the country in areas such as communications, leadership, and racial equity. She's also a senior attorney and communications director at the Prosecutors Center for Excellence in Manhattan. Jennifer, thank you so much for joining us today.
Oh, I'm so excited to be here. Thanks for inviting me.
So we have a lot to talk about today, but before we get to the issues I highlighted just a moment ago, we do have some relatively breaking news. Yesterday, the Eighth Circuit Court of Appeals issued a ruling in a civil suit involving the conduct of St. Louis police officers in September of 2017. Now, we're talking about the night of the famous kettling incident. Police cornered, arrested, and maced approximately 125 people, and that includes an undercover officer who was beaten. We discussed the criminal trial against his fellow officers last month. Now, many of the people who were arrested over that weekend filed lawsuits. 3 of them filed the class action lawsuit that led to yesterday's ruling. They urged the court to issue a temporary restraining order and injunctions requiring the city of St. Louis to declare protests unlawful assemblies and to order protesters to disperse in a constitutional manner and otherwise limit police activities at protests. The court issued that injunction and sent the case to mediation. Now, as the months turn to years, the city has sought to dissolve the injunction. They also challenged the idea that this made for a class action lawsuit. And that brings us to yesterday's ruling. The court agreed with protesters that the injunction should stay for now. But it also agreed with the city that this was not necessarily a class action lawsuit. And so I'm curious to hear from our panel, what do you make of this ruling? Mark, do you think the appellate judges got this right?
Yeah, I don't have a big problem with it. I mean, the 2 issues, I think the class action one is the simpler one. And basically, they weren't saying it was necessarily inappropriate for class action. They just said these 3 people were very different. And when you do a class action, you have to have people kind of having the same kind of injuries, the same kind of background. And this was different. One was maced, one was an observer, one was doing something illegal. So the court said they're very different. In terms of the injunction, this has been going on for, I think, 4 years. So they said they were basically saying you got to get this to trial and look at the issues, and we can't just leave this preliminary injunction in place forever. And so, and they said for police officers who are following, orders, and it may subject them to a contempt of court citation that they wouldn't otherwise get, and so it would be unfair to them. Having said that, what the injunction says, you can't violate the Constitution. So it seems like it's not that big a deal.
Yeah,
And,
let me cut in here. Jennifer, don't police officers always have to follow the Constitution? Why is it necessary to even have this extra injunction on top of that?
I'm not really sure, but I think that the point that the Eighth Circuit here was trying to make was that this is taking a long time. I think I could see that they're very frustrated with this because it's a temporary injunction. It's a preliminary injunction, and that's not supposed to go on for years.
And at this point, we're looking at 4 years on this thing.
Right. So they put some language in there that I think makes it really clear that they expect this to be resolved in 6 months.
Sarah, what about these issues of class certification here? Do you think this is going to be a big problem for the ACLU pursuing this as a class action with what the court has said here?
I think it is. And I think this order is a win for the city of St. Louis. I think this is a loss for the ACLU, for the protesters. I'm going to touch on the preliminary injunction for a moment. The judge held 3 days of hearings. It was October 18th, 19th, 23rd, and 2017. She said, go to mediation in 6 months. They did, and then the parties kept continuing it, and the city never appealed the injunction. And so when the appeal came around 2.5 years later, for the first time, the city tried to appeal the injunction, and the dissent in this case, Judge Erickson, said they didn't appeal it. It's too late. You've waived that argument. We should not lift this injunction. But the Eighth Circuit did it anyway. And I agree that the Eighth Circuit said this is taking too long. That's certainly what they said, but that's certainly no fault of the judges. It's the fault of the city. And the judges said at the appeal, it's just a re-argument of the initial hearing on October 18th, 19th, and 2017. And so I think that, respectfully, it's always going to come back and bite me. I think the panel got it wrong. I agree with the dissent. As far as the class action, again, I think the panel has signaled to Judge Perry that she should not certify this as a class. There are 4 requirements for class action. One is numerosity, meaning are there a sufficient number of people involved? The second one is commonality. Are they pursuing the same type of claims? Are they asserting the same arguments in this case? I would say yes, that they're all claiming that there's an unconstitutional violation of police practices and policies. The next one is, are the claims or defenses similar enough? And then the last one is, will the class representatives fairly represent everyone, not just themselves? And the Eighth Circuit came in and they said, well, we're not going to decide the merits. We're not going to decide the merits of whether all 4 of these elements are met. But in not deciding the elements, the Eighth Circuit said their harms are different. These are a bunch of discrete claims that you're trying to all jumble together. They have different harms, and they're already pursuing monetary damages from the city. So really, what's left? All that's left is the declaratory judgment, and we think the class action is premature. So I think they've signaled to Judge Perry, don't certify this, which I think is, again, a win for the city and a loss for the protesters.
Jennifer?
Yeah, and it did. One thing that I thought was interesting about this opinion was that there's language in there that if the plaintiffs engage in any more discovery, that the injunction is dissolved forthwith. What do you make of that, Sarah, if I could ask?
That's absolutely punitive. So the Eighth Circuit says it's premature to decide if it's a class action, but if you dare test it and want more discovery to figure out if it is and can be a class action, we're going to take away your injunction. It's absolutely punitive, and I was frankly offended by it. respectfully offended by the panel's decision. I think the ACLU knows, I think they probably are reading the tea leaves that they need to get their trial in before October. And then maybe after October, if the judge does go from a preliminary injunction to a permanent injunction, maybe at that point they can request discovery and say, well, it still complies with the judge's order. But I think this is a punitive assessment by the Eighth Circuit.
It seemed a little harsh.
And frankly, it's a conservative panel anyway, so I can't say I'm terribly surprised.
So I'm kind of interested in the politics behind this thing. We now have a new mayor in the city of St. Louis, brand new, and she has maybe a different perspective on some of these issues than her predecessor would have had. Mark, how does that play into the timing that the court has just put this on?
Yeah, that's what I was going to ask too. What did people think about that? Because, you've got a different defendant now than you had before. And, I don't know that Mayor Krewson was trying to take a real hard line, but I think the new mayor will probably be more accommodating and more demanding of the police officers. And so they may, resolve this and reach some kind of settlement that is more to the liking of the protesters and the ACLU.
And yet, Sarah, you're saying the city's now in the driver's seat on this one. The fact that this ruling went the way it went, they should have a stronger negotiating position if the city wanted to take a hard line under a new mayor.
So that's what the panel said. The panel said 4 years have gone by. The defendants are different. The everything is different. Everything is different. And in the dissent, Judge Erickson said, there's nothing about the passage of time that makes it different. It's the same policies. It's the same handbook. It's the same practices. It's the same unconstitutional dispersing of protesters exercising their First Amendment. There's nothing different other than passage of time. I would agree with the dissent here. It's I'm sure if we have I shouldn't say I'm sure, but I suspect if we have another protest in the city, the same tactics are going to be used. Taking protesters' cell phones, using chemical agents. I don't think anything in our police department will change or has changed. So I don't think passage of time and new mayor is enough to change our police.
Jennifer?
Well, and we do have a new mayor, that's for sure. But if you look at who's in charge of the police department, the director of public safety, there's nothing new about that. That's Dan Isom. He's been there before. I was circuit attorney when he was chief, and I can tell you, he's got somewhat of a conservative view, in my opinion, on these types of issues. And whereas Mayor Jones might not have a conservative view, I think Isom has a track record on these that, I remember in a number of cases where he declined to put the officers forward for charges when the public was crying out for that. So it'll be interesting to see how that plays itself out. And then as his deputy is Heather Taylor, who former president of the Ethical Society. So I think it's really fascinating right now in terms of the management of the police department. Mark, I know as a former police commissioner, you're probably watching this very eagerly as well.
With John Hayden as the chief, he was not the chief when this happened. That was, you had O'Toole as the interim chief, I think. And so you do have some different players and certainly a different mayor. So, I mean, if it were me, if I were betting, I would think they're going to work this out before the 6 months is up.
Question for Sarah, since you feel like this, you don't agree with what the panel decided here. If you were the ACLU attorney on this, do you see grounds where you could appeal this and try to take this to a higher level?
Realistically, probably not. I mean, so in the Eighth Circuit, there are probably 20, 25 judges, but they don't all sit at the same time like the U.S. Supreme Court. You don't get all 25 judges sitting in here hearing a case. You get 3 at a time. You get 3 judges who do give a panel decision. And if you don't like that decision, you can request an appeal or a hearing in front of all the judges, and that's considered an en banc, meaning it's the whole bank of judges. The ACLU could appeal to the en banc judges, and there's probably 25 judges, including senior judges, but I would guess en banc is 16 or 17 judges. Historically, Eighth Circuit has been a fairly liberal circuit. In fact, the all the sports teams wanted their CBAs negotiated in the Eighth Circuit so that if they lost, they had a union-friendly, more liberal circuit to decide their cases. I would say in the mid-90s, the Eighth Circuit started turning, and it's now one of the very most conservative venues. And so, in fact, the sports teams no longer negotiate their CBAs in the Eighth Circuit. They've moved over to the Second Circuit, New York. And so the ACLU could request an en banc hearing with all of the judges, but given the disposition tenor of most of the judges in our Eighth Circuit, I would think that they would probably lose, right? And you don't want to pour salt in the wound. I think the ACLU, if I were advising them, I'd say, you got a friendly mayor here who probably wants to put this behind her. She doesn't want this to drag on during her tenure. She's probably more apt to settle. If you try to appeal en banc, that could take a year to 18 months. If they actually take your case, or if they actually hear it, let's try to negotiate a settlement. That would be my recommendation to them.
We need to take a quick break, but we'll be back shortly with our panel to continue this conversation. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.
And now back to our legal roundtable. I want to talk about another case involving the city of St. Louis, and this involves the city's earnings tax. This is a hot topic this month. The city requires that people who live here or work here pay 1% of their income in taxes. It's a full third of the city's revenue. And now, thanks to the pandemic, many of those workers have instead been working from home. Do they still have to pay their 1%? Well, the city says yes. There's now some lawsuits over this. Does the city have a leg to stand on? Mark, what do you think about this one?
I think this is going to be a tough one. In the past, if you worked downtown, but you lived in Clayton, and then you were traveling for work, so you were not going downtown, you would get a refund for that section of the earnings tax. And they are saying, well, if you're traveling, we'll still let you do that. But if you're just working from home, you're now in Clayton, we're not going to do that for you. Also, one of the plaintiffs in this lawsuit apparently had been telecommuting before and was getting a refund, and now is not getting the refund. And so they're making an equal protection claim, among other things, saying this is unfair and it's not, and that we shouldn't do it, or that the city shouldn't be able to take the earnings tax from them. As someone who lives in the city, city needs the money, but I think it's probably a pretty tough argument. I also think some businesses are going to just, if these workers end up working long-term outside, the city of St. Louis, they'll create some secondary place and say they're working from there.
Just to save their workers that money.
Just to get around it if they would lose in the courts.
Wow.
That's a 1% raise for your employees that doesn't cost the employer anything. The other thing, I think this case was originally filed in federal court. Now it's in state court, so it's going to take a while. But
and I want to bring up this particular point here, Jennifer. I'm very curious what you think about this. The attorney who filed this, Mike Milton, he said he thought he might get a fairer shake in federal court than from a St. Louis Circuit Court judge because the Circuit Court judges rely upon this city revenue. You spent a lot of time dealing with the city Circuit Court. Do you think that's a valid concern on his part?
No, I don't. With all due respect to him, I think a lot of the judges' expenses are met by the state instead of by the local coffers. And, the lawyer for the collective revenue here, Dave Luce, is a very sharp guy. I know because he has represented me on things, and he rightfully got it moved to state court. And it will take a while, but I think the state court judges can give this just as fair a hearing as the federal court. The thing that made me shudder when I read this was Mr. Schock, one of the lawyers for the plaintiffs, his guess that 75% of the people who pay earnings tax actually live outside of the city. Oof. And so if even half of those people were working from home, that is a devastating blow. So I don't blame Greg Daly for fighting this. This is a lethal blow to the city, possibly. The city may have to completely alter its budget if this lawsuit is successful. But to piggyback on what Mark said, I think it's a tough argument for the city. I mean, before they said, well, you're using computers that are downtown, so we should still get the earnings tax. Well, that's kind of a strange argument to make.
Yeah, and in one of these cases, the guy filed an affidavit. He found out that his computer network was based in Minneapolis. I feel like that kind of shuts that out. Sarah, do you share the skepticism of Mark and Jennifer? The city could be in trouble on this.
Yeah, they're in trouble. They're definitely in trouble. I mean, last year they gave out $2.9 million in refunds to 4,000 people, and they said, "Well, what's different?" And they said, "Well, it's different because of the pandemic." That's not really a valid defense to. It's not really a valid defense to why people don't get their refunds. And frankly, I think there's probably an argument under the Hancock Amendment, that you can't functionally raise taxes without a voter approval, and the tax threshold can't be above 5.6%. And so I think, there's an argument that by refusing to give the refunds, they're violating the Hancock Amendment.
Oh, boy. Well, as a city resident, This strikes fear in my heart. If this is just all on the backs of those of us living here, we may be in trouble. One last very quick thing I wanted to get the panel's take on, and this is another unusual thing involving a judge. U.S. District Court Judge Catherine Perry, when this was still in federal court, she disqualified herself from hearing the case because she said there is a chance that its outcome could affect court employees, including those who report to me that these might well be county residents who are stuck paying this tax and maybe haven't been having to come into the courthouse. I've seen judges resist recusing themselves for what feels like far less to me. Is anyone else struck by that this just seems like she shouldn't have to disqualify herself for this? Jennifer?
Well, I don't know, because in the federal system, the court employees really have a very active role. The law clerks, sometimes write the opinions of the judge, or do a lot of the legal legwork, and I think that it makes sense to try and avoid any conflict of interest on their part if they're going to really be doing the initial research and analysis on these issues. Obviously Judge Perry will give it the thumbs up or the thumbs down, but the law clerks in federal court really do a lot of the work of the judge, at least initially.
And federal judges have a great deal of discretion in this. Judge Perry is a great judge, utmost integrity. I mean, I'd rather have a judge recuse themselves than not. I think erring on that side is not a bad thing. I also think, this is not a legal issue, but it kind of goes to, it's a tax issue when you have St. Louis balkanized like it is, and and granted, I have a vested interest because I live in the city, but, if you make cuts to policing, people come into downtown for baseball games, other entertainment venues, St. Louis City benefits, I would argue, the whole region, and yet the costs are all in one place, and so you've seen things like with the zoo, this district to try and bring in revenue for something that everyone enjoys. It would be great if we could do something like that. Although I'm sure my friends in the county are saying, "Yeah, I'm not
Yeah, I don't think they're going to sign on
anymore. Right?
They don't even want to pay the 1% anymore. They're not going to sign up for that plan, Mark. I want to talk about something involving state government. This relates to Medicaid expansion. The state legislature appears poised to approve a budget that contains $0 for Medicaid expansion. That's even though voters just last summer approved a constitutional amendment to expand the program. My big question is, can they just do that? Everybody says this is going to come down to litigation unless they blink at the last minute and add this funding. On its face, Sarah, does either side have a stronger case coming in?
Boy, this is a tough one because you look around and you say, who are we going to? Well, let me give a little bit of background here. It is really hard to qualify for Medicaid in the state of Missouri. If you are an adult, you don't get it. If you are a family of 3, you have to earn less than $5,400. And so the centerpiece of Obamacare, the Patient Protection Affordable Care Act that we all know as Obamacare, wanted to expand eligibility, that you didn't have to be so dirt poor. And as we all know, Obamacare has had lots of fights about its validity. And in 2012, the Supreme Court said, okay, we're not going to force this. The Medicaid expansion won't be forced on the states. The states have to accept it willingly. Our Republican legislature hasn't wanted it. And as what you said, the voters passed it last August. And so now we're at the funding. Parsons, I think, put in $1.9 billion for the Medicaid expansion. The Republicans have gutted it. I think the House Appropriations Committee didn't allot anything to it. And I think this week or last week, a Senate Appropriations Committee said, well, all right, we'll do $60 million. Mm-hmm. We'll throw $60 million at the expansion. And what they said is, we'd rather allot some rather than get sued and rather than put the issue in the hands of a judge. I think if you were going to sue I think it was Missouri Health Net. I might be botching. No, it was Healthcare for Missouri is who led the ballot initiative. Mm-hmm. And I assume that if there isn't funding in the budget for the Medicaid expansion, Healthcare for Missouri will find a plaintiff or be the plaintiff, and they will likely, I would assume, sue the executive branch, because the executive branch is who oversees the Missouri Department of Social Services, which then sort of funds and oversees Health Net, which is the Missouri Medicaid. Mm-hmm. So if I were bringing a lawsuit, or if a lawsuit were to be brought, I think it would be by Healthcare for Missouri against the executive branch. I think the issue is a judge may say, yes, the voters approved it to not have the Medicaid expansion in the state violates this constitutional initiative. But I don't think a judge can say, and you must allot 30 million or 90 million or 100 million. A judge can't say how much to do. I think a judge would just say, you got to provide it. Come July 1, you have to, the eligibility criteria will expand to match whatever the Obamacare required. And people who in that criteria can go get services. And, I think a snowball effect will occur that if it hasn't been funded in a year or 2 years or 3 years, we're going to be looking at a giant deficit. So I think a plaintiff can win the case, but I don't think a plaintiff can force them to fund it.
That's interesting. So they'd have to provide these services. So the funding would have to come from somewhere. But especially, as you say, if they're trying to sue the executive branch, the governor's already in favor of this funding. He just can't get the legislature to go along with it. Mark, thoughts on that?
And this was the vote we had was for a constitutional amendment. So the legislature can't undo this. So it's in place. And so, like Sarah was saying, I think what will happen is, and I think there's still a good chance at the last minute the legislature could fund this or fund some important portion of it. But let's say they don't, and they leave all this federal money kind of sitting out there, not being used by the state of Missouri. Then I think what will happen is you'll get some people who qualify under the Constitution. They'll apply for benefits. They'll be denied because there's not enough money, and then they'll bring some kind of action to force them to give them the money that's required under these programs. And under Medicaid, when you participate in Medicaid, there are federal requirements that have to be followed. The states have to follow these. So, Missouri will be found in violation of either that, or there'll be some kind of, I forgot what it's called, but where you force an official to do their job. And I think eventually the state's going to have to come up with the money, because it's just going to be, there'll just be more and more lawsuits here. But yeah, some judge is going to be very hesitant to say you have to fund this, because that just plays into what the Republicans are saying of legislating from the bench, and it would be tough to enforce, I think.
And as Sarah said, there was this attempt at a compromise to say, let's give this partial funding. We don't want to give the judges this power. That stalled out with a tie vote in committee. And it looks like at this point, unless somebody reverses this in the next couple days, boy, it is going to be a judge. They're going to do exactly what they said they didn't want to do. Go figure.
I got to believe the governor wants to get this resolved.
And I would agree with Mark. It is a constitutional amendment now, so they can't undo it. But I could see the legislature taking steps to slow it down and delay it. For instance, there was an amendment to have a wage increase, minimum wage increase starting, I don't know, this year, next year, I can't remember what. But just this week, there was a House Special Committee on House Bill 726 to slow the implementation of our state's minimum wage so that it doesn't increase as much. They can't undo it, but they may take steps to slow it, delay it. And that might just be failing to fund it as just part of that tactic. They know they will have to do it eventually, but they think, I'm going to get termed out in 2 years, 4 years. I'm going to vote no, so it's not on my watch. And when the next state legislature comes in, we can say how bad they are, that they haven't balanced the budget, and we're so far behind.
It's very depressing when you put it that way, but sadly, I think probably you may be accurately diagnosing what's about to happen here. We need to take a quick break, but we'll continue our roundtable discussion when we return. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.
Welcome back. Before we return to our conversation with our legal roundtable, we have a quick programming note. Bird watching is on the rise. Have you been paying closer attention to birds during this pandemic? Have you noticed behavior that you find yourself wondering about, or maybe just something cool you want to report? You can share your observations ahead of our discussion on tomorrow's show. You can leave us a voicemail on our dedicated voicemail line. That's 314-516-6397. 314-516-6397. Or you can send us an email at talk@stlpr.org. And make sure to tune in for that one. It'll be tomorrow at noon and 7 p.m. And now back to our legal roundtable. I want to talk about something that kind of affects the whole justice system here. Jury trials are again underway. They have not been without hiccups. In some cases, in order to make these things work, you have courtroom proceedings in one room, interested parties in another room, and in some cases, the internet connection between the two rooms have dropped. One example, when they announced the verdict in the case against the St. Louis police officers accused of beating an undercover colleague. This was huge news. And the reporters that were in the room waiting for this news to be reported, the internet access cut out right as the verdict was about to be announced. It was a cliffhanger there. Now, the reporters got that news. They got it within the hour. But in other cases, it does appear that there's some trouble with observers getting to see these hearings. And traditionally, most court hearings, almost all court hearings, are open to the public. Jennifer, Joyce, is it a problem that in this age of COVID, these tech malfunctions are limiting the people's access to what's going on in these courtrooms?
Well, I think we have a whole lot of what I call looming legal issues across the country right now as we transition out of a lockdown into having trials and things again. I know that this is creating just unprecedented challenges for prosecutors, and I assume public defenders as well. Every jurisdiction, I work with prosecutors all over the country, they have huge backlogs. And it's like just a tiny little trickle of cases are getting through, and there's this huge backlog behind it. The confrontation clause issues, when these are broadcast and there's technical difficulties, it remains to be seen. I think an argument can be made that besides the best intentions of everybody, the public couldn't hear it. How are courts going to view that is a very good question.
Jennifer, let me cut in here. Are you saying that could be grounds for appeal if somebody is convicted at a hearing where the public didn't have access?
If I were the defense attorney, I would appeal on that ground. I don't know if it'll carry the day, but I think it's worth discussing. And you never know what's going to happen. I mean, this is really an unprecedented situation that American courtrooms find themselves in. And there's the opposite side of the spectrum, too. I know I think it's in Michigan, they show all the court hearings and trials and stuff on YouTube where everybody can see. And so that's a huge, violation, some people say, of their right to privacy. Because it's one thing having an open courtroom, and then it's over with, or people can come and watch and then it's over with, or maybe even online for a little bit. But to have it on a YouTube channel forever, and you get into all kinds of stuff like witness intimidation and things of that nature in criminal cases. So I'm sorry I don't have an answer for you, Sarah, except to say that this is a huge mess, and it's going to be a while before the courts are able to sort all of this out, and a lot of it is cases of first impression.
I want to talk a little bit about what's happened because of the fact that so many cases have been in the pipeline for so long. I mean, this is causing some huge problems in the jail system as well. I think a lot of what we've seen, the mayor did her impromptu visit to the jail and talking about people being held there for very long lengths of time. Sarah, this seems like this is an even bigger issue if they can't find a way to get these things going again.
Right. Well, I can't speak to the criminal side. I wouldn't know how to get anybody out of jail. But on the civil side, yeah, my clients have a constitutional right to a jury trial in most of their cases, unless it's stated otherwise in a statute. And my clients want their day in court. And what I've discovered personally, anecdotally, is particularly St. Louis County, the judges are requiring mediation. The judges know that there is a huge pipeline coming behind them, just waiting to burst open. And so many of the judges in their case management orders are requiring mediation.
Is that a good solution?
Probably.
Okay.
It probably, realistically, it probably is. 98% of cases settle, and defendants and plaintiffs, sometimes a party thinks it's weakness to say, hey, do you want to talk settlement? It's not a sign of weakness. It's reality, because 98% cases settle. And so by the judge requiring it in a case management order, sometimes it gets that issue percolating sooner rather than later, and maybe it will resolve some of the congestion. And in order to mediate does not mean settle. It just means the parties are ordered to talk about settlement. And so is it going to solve the problem? No. Is it going to alleviate some of the problem? I hope so, because most defendants right now, time is money. Why pay a settlement today if I can pay a settlement in a year? On the civil side, most defendants really aren't inclined to settle right now, but the courts are making them have the conversation.
What about on the criminal side? I get on the civil side that there's a little less pressure. Here we're dealing with people's livelihoods. And in St. Louis, this has been a huge issue with people who are being locked up waiting for trial. So a trial being delayed, that's a problem. Jennifer, what do you think about all that?
It is a problem. And I think what's lost a lot is that delay typically, with respect to the trial itself and the ability of the prosecutor to prove guilt beyond a reasonable doubt, delay tends to favor the defendant. Cases never get better for the prosecutor as they get older. They only get worse. So prosecutors have every incentive to move these things as fast as possible before witnesses forget, die, decide they don't want to cooperate, what have you. I don't know exactly what's going on right now in the prosecutor's office, but I would assume that they are doing what I see all over the country, which is they are looking through their dockets and trying to determine what can they negotiate out. Kind of like what Sarah was saying. It's the criminal version of mediation. What can we do here? What lower level cases, what cases where somebody, maybe it's their first offense, or, taking a hard look at those and seeing if there's an alternative disposition or a way to, plead this case out without having to go to trial. Having said that, there are a large number of cases in the city of St. Louis where people kill each other, and rapes and armed robberies and things of that nature, whereas we've seen in recent days, it's very dangerous to have those people housed outside the jail. So I think I gotta believe, and I know that yesterday somebody said on your show that there was someone in the Justice Center for 9 years. Mm-hmm. I'm fascinated by that, because I don't know how that could be, except that they just fell through the cracks. So I'm actually trying to get to the bottom of that, because that just makes no sense to me. I can't imagine that they have a lawyer and they're there for 9 years, or that the prosecutor knows about the case and they're there for 9 years.
So I understand on that one, that appears to be a capital case, and apparently the Attorney General's office is getting the chance to bring this again after, it sounds like a unique set of circumstances, but as you say, 9 years. I mean, my jaw absolutely dropped. I didn't think such a thing was even possible.
I didn't either. I mean, I would hope that now with COVID and everything else, that population in the Justice Center has been combed through, and only the absolute necessary people are there. In St. Louis County, in their system, they have I think it's a MacArthur grant or something like that, where they have this program where they go through and automatically weed out all the lower level cases and analyze those and get those out of the jail situation. I would hope that we're doing something like that in St. Louis, but the fact of the matter is it's a very violent jurisdiction, unfortunately, and until that changes, we need some bed space for people. There's no two ways about it.
It's such a tough situation, and it seems like getting these jury trials up and running, even though this is incredibly difficult, this is just absolutely essential. Mark, any thoughts on what needs to happen?
I would just say, I think you got a bigger problem on the criminal side, because you have a constitutional Sixth Amendment right to a speedy public trial. And but I thought what Sarah was saying was interesting. This mediation, federal courts have been doing it for over 30 years, forcing mediation, and a lot of times, if you have parties, neither side wants to look weak by suggesting mediation, and it's easy to push things down the road. And if you're forced to do it, maybe you get it taken care of. Everyone realizes, litigation never helps anyone. It's never a good solution. If you can cut a deal, it's much better. And so maybe this will have some positive effects on the civil side. I think the criminal side is going to continue to be a challenge.
Let's talk about something else involving the federal court. They have taken steps to make it harder to seal documents. This has been a big push by the St. Louis Post-Dispatch. I know as a journalist, I've been pretty frustrated. Trying to get records in federal court seems to be increasingly difficult. Now this new rule says that all documents and materials submitted to the court, quote, must be filed in the public record unless rules specify otherwise. And this, again, is coming out of the federal court here in St. Louis. Sarah, does this strike you as a good move?
Oh, I say praise Jesus. Yeah, I think it's a fantastic decision, and I applaud Judge Clark for doing it. So many defendants want to hide information in sealed documents, and I'm not talking like protected health information. I'm not talking about somebody's name and their address and their, medical condition. Of course, I don't want that out in the open either. There's no business for it, but they want their handbooks. They want their handbooks under seal, their policies under seal, and it's ridiculous. And there's a gentleman out there, and I don't know his name, and I should know his name. He he was a plaintiff's attorney who saw a problem with a gun, and he went around to all the jurisdictions in the different states where there was a lawsuit related to a gun. And all of the information, many of the exhibits were filed under seal. And he went around contesting all of these documents that were filed under seal. And he eventually put together, and he said the gun lobby has known about this issue with this gun for all of these years, and the public doesn't know about it because everything is filed under seal. And he was able to bring to light this really, I wish I could remember the guy's name, but he was able to bring to light this problem with this gun that the gun lobby was hiding. And the same thing has happened with the automobile manufacturers. They know their airbags don't work, or they know their seat belts don't work, and they hide all of the information under seal so that it doesn't come to light. So the issue never gets corrected. It's a travesty. It's an absolute travesty. Under seal was not meant to hide bad information about your company. It was to protect individuals' real privacy or trademarks or copyrights or your real internal secrets, just not the bad stuff about you. And I'm sure Jennifer can comment on the criminal side of it, keeping certain victims' information under seal. But I say hallelujah, Judge Clark. Thank you.
Jennifer, do you see a potential downside to this as relates to the criminal side of things?
Well, it's not necessarily a downside, because I assume that this is something that would be taken into consideration when judges are deciding whether to file something under seal. And I think Sarah makes excellent points with respect to the civil world, and I 100% agree. But there are situations in criminal world where an investigation can be completely blown if information is leaked about it. I remember one time the police from Minneapolis, they had a series of homicides up there, and the person they were suspecting of it moved to St. Louis. And they came and worked with us to do a search warrant, and they prepared an affidavit for our courts for a search warrant. And they filed it, and they didn't ask that it be filed under seal. And the next morning in the Post-Dispatch on the front page was the complete affidavit for the search warrant and all of their investigation and everything else. And this guy had no knowledge that they had him as a suspect. And then it was on the front page. So, I mean, that was completely blown. And then to Sarah's point, again, there are victims, there are locations of things that need to be protected, investigations need to be protected. So my hope is that this is all taken into consideration. Mm-hmm. I agree that things shouldn't just be under seal because they tend to be unflattering. And I think that that's what we have evolved to in general.
Sarah, it sounds like the pendulum had swung to the point that companies were just assuming or relying on the fact that things could be filed under seal, and there wasn't much pushback.
I will tell you, in every single civil case I get, the defendant insists on a protective order. And a protective order says, you can't use these documents or this information for anything other than this case. And then they stamp every document confidential, confidential, confidential. So they don't want their documents being circulated among plaintiffs' attorneys or class action attorneys to build a case against them. That makes sense to me. But they're now starting to insert in their protective orders that they can file anything under seal anytime they want. And I have to push back and I say, no, that's the judge's decision. And if the judge says no, then you can't file it under seal, that you don't get an automatic right to it. And I have been fighting that for the past couple of years, and I'll tell you, it's mostly been successful. And the judges will say to the defense companies, "No, you don't have the right to file anything under seal. You need to come and get permission." So at least we're holding that wall. But for Judge Clark to come in and sort of ratify this rule, hopefully subside some of the arguments I'm hearing from the companies.
Well, in our final 30 seconds here, Mark, do you also approve of Judge Clark's move on this?
I do, and I can't improve on Sarah and Jennifer's analysis, though. They did a great job.
Yeah, it's been so interesting to hear about some of these things involving courts and how things work behind the scenes. I want to thank our legal panel for sharing their expertise with us today. That includes Mark Smith, who's the Associate Vice Chancellor and Dean for Career Services at Washington University. Mark, always so good to have you here. Thank you.
Great to be back.
And Sarah Swatosh, a partner at Sadeh Harper Westhoff. Thank you.
Thank you.
And last but not least, former St. Louis Circuit Attorney Jennifer Joyce, now a consultant helping prosecutors around the country. Thank you for joining us and sharing your expertise.
My pleasure.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations, and leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thank you.
St. Louis Public Radio is a member-supported service of the University of Missouri, St. Louis.
Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.